The ultimate goal for any civil judicial process is to render a valid judgment. A valid judgment is a judgment that is enforceable and that is consistent with the rule of law. Now, in order to get that valid judgment, the court that is issuing the order has to have judicial authority. Remember, from video 1, there are 3 necessary components for judicial authority: personal jurisdiction, subject matter jurisdiction, and notice and service of process. If any of these vital components are missing, you will not have a valid judgment. And if you don't have a valid judgment, the orders are not only voidable, they are void. Personal jurisdiction has 2 phases: power and authority phase, notice and service phase. Remember? Power and authority phase has 2 components. It has the statutory authority component and the constitutional authority component. With the statutory authority component, that is a rule that authorizes jurisdiction within the state. That's a state rule. With 50 states who may have 50 completely different statutory rules, especially long arm statutes, because we are focused on non-resident defendants, you're not going to spend a lot of time on statutory authority. There's too many for us to cover. However, where we will spend our time is on the constitutional authority. That's the due process clause. And it's the due process clause that places limits on just how far the state statutory power can reach. For state courts, that constitutional due process limit comes from the 14th Amendment. Now, if we were addressing federal courts, we'd be looking at the Fifth Amendment. But right now, our focus has been on the 14th Amendment. The foundational components of personal jurisdiction will never change. Well, they haven't changed up until now. So for in the foreseeable future, those 2 foundational components won't change. Again, those 2 foundational components are statutory authority and constitutional authority. Now pay attention right here, because what will change is how the constitutional authority is satisfied. That is the litany of cases that you are going to analyze as we progress on this evolutionary arc of personal jurisdiction. We're going to start with Pennoyer v. Neff, and we're going to continue upward and onward with our focus on the refining of what is required to meet the constitutional authority. In other words, what does it take to satisfy the due process requirements? That's what we're going to focus on as changing. Okay. Before we get into Pennoyer v. Neff, it's really critical that you understand the three categories of personal jurisdiction. There's the in personam category, there's the in rem category, and there's the quasi in rem category. With the in personam category, the definition is the court's authority to enter a judgment binding the defendant personally. That means that the defendant is personally responsible for paying whatever that judgment award is. So, in personam jurisdiction yields a personal obligation. Does that make sense? The court's authority to enter a judgment binding the defendant personally, making that judgment enforceable against all of the defendant's assets wherever they're located. This means that the defendant is legally obligated to pay the awarded amount. Now, once the judgment is obtained against the defendant, there's various ways to execute that judgment. For instance, you can get a writ of execution where the sheriff will seize property and sell it to satisfy the judgment. You can get a garnishment, you can get a lien, but we're not going to get in deep with methods of debt collection or methods of satisfying judgments. But it's enough to know that once you get that judgment against the defendant personally, there are ways to turn that paper, the judgment, into money. Let's move to the second category. The second category of personal jurisdiction is in rem jurisdiction. In rem, R-E-M, jurisdiction. It's defined as the court's power over property that is subject to the ownership of the defendant, and the property is the subject of the lawsuit. What do I mean by the property is the subject of the lawsuit? That means that it's the property that the plaintiff is suing to obtain. The plaintiff isn't suing the defendant to obtain a judgment that can turn into money. The plaintiff is suing the defendant for a specific identifiable piece of property. Here's a classic example. Let's say we have an action to quiet title. You'll learn more about that in property law. We want to quiet the title to Blackacre. A is the plaintiff and claims that Blackacre is theirs. The defendant is B, and B says Blackacre belongs to them. A sues B regarding the ownership of Blackacre. Blackacre is part of the lawsuit from the onset. It is the subject that the parties have a dispute over. The court is going to adjudicate the ownership of Blackacre. And once the court enters an adjudication regarding Blackacre, not just the defendant, but the whole world is on notice as to who the owner of Blackacre is. Does that make sense? So it's the plaintiff who is suing the defendant specifically for this piece of land. And Of course, because we're talking about non-resident defendants. The land in question must be within the geographical boundaries of the forum state. That's in rem jurisdiction. The third category is quasi in rem. And quasi in rem is what it sounds like. It's kind of like in personam, and it's kind of like in rem. So here's a better description. The court uses the defendant's property, that is, right, located in the forum state, as what we like to refer to a jurisdictional anchor, right? It's an anchor to adjudicate the personal claim against the defendant. And the property that is being used as an anchor is not the subject of the lawsuit. Take a moment, right? So if it's quasi in rem, that means that there's a piece of property in the forum state. Plaintiff A identifies that piece of property at the beginning, at the onset of the lawsuit, and says, I don't want this property, but this property is in the forum state. This property is owned by the defendant. I want to use this property, right, to anchor the defendant within the state. And it's going to be this property that is going to be utilized to satisfy this personal claim against the defendant. Does that make sense? So here's an example. Actually, the perfect example is Pennoyer v. Neff. Now, Mitchell, who is the original plaintiff in the original lawsuit that begets Pennoyer v. Neff, is a lawyer. Mitchell did not do this in this case, but Mitchell could have proceeded in this direction. Mitchell had a claim for unpaid attorney's fees from Neff. Mitchell wanted his attorney's fees. Mitchell could have attached Neff's property if Neff had property in the forum state at the time that the lawsuit began. Mitchell could have attached that property at the beginning of the lawsuit and said, I don't want the property. I want my personal claim. I want my money. But Neff is an out of state defendant, and I want to anchor him here in Oregon. So we're going to do that by attaching that property at the beginning of the lawsuit so that as I go forward on my monetary claim against Neff, and when I win that claim, I've got this piece of property specifically identified from the beginning, right? That we will now sell to satisfy my money judgment. That makes sense? Quasi in rem is almost, I guess, anticipating a win. And when I win, I want to take this property. But the defendant is on notice from the very beginning that a piece of his property is at stake here, right? It's not done after the fact in order for it to be quasi in rem. Does that make sense? Yeah, take a minute, think about that. Let's do just a really quick overview. in personam, power over the person. The person has an obligation to pay that judgment if a judgment is in fact granted against them. In rem, the plaintiff isn't interested in a general money judgment. The plaintiff is interested in a specific piece of property. That property is identified and attached at the beginning of the lawsuit. That property has to be within the geographical boundaries of the form state. The plaintiff is not interested in this property, but will attach this property as a means to anchor the defendant in the form state's jurisdiction and as a means in anticipation to satisfy the judgment if the plaintiff in fact wins the judgment. Got it? Three different categories of personal jurisdiction. So what? Here's the so what. These three categories, in personam, in rem, and quasi in rem, are the landscape of Pennoyer v. Neff. Pennoyer will draw a bright line around in personam jurisdiction. In personam jurisdiction is going to be the highlight of the Pennoyer v. Neff case. And at the end of Pennoyer v. Neff, the United States Supreme Court will have constitutionalized the concept of personal jurisdiction. Ultimately, what the United States Supreme Court is going to say about personal jurisdiction, if it is the in personam category, the United States Supreme Court is going to say publication for an out of state defendant is not sufficient if it's in personam. And if it's in personam, the only method of service that will meet constitutional muster is going to be personal service inside the geographical boundaries of the form state. Now, of course, you can always get power over the defendant if the defendant consents. But if the defendant consents, then we don't have a legal issue over the personal jurisdiction, right? Okay, moving forward. Pennoyer v. Neff, as it relates to personal jurisdiction, is very important because it acknowledges separate categories of personal jurisdiction, right? It acknowledges in rem jurisdiction, where property is located in the form state, where the plaintiff actually wants the property. And it's going to highlight the difference between that and controversy surrounding quasi in rem. So it's going to help us distinguish categories of personal jurisdiction that is going to have a greater opportunity to ensure that defendants aren't being subject to the loss of land without due process of law. Get it? 14th Amendment, the due process. Excellent. I know. So exciting. So exciting. Pennoyer v. Neff. Just a real, very quick recap, because I know that this makes sense to you now. Mitchell filed the case against Neff in personam. That's that top category. In personam, I want Neff to be personally liable, right? because these are unpaid attorney's fees. So ultimately, what Mitchell wants is his money. He didn't want a piece of property. He wants his money. Mitchell could not have filed in rem. Why? It's not the property that he wants, right? And there's some ambiguity as to when Neff actually obtains title or possession, well, title to the property that is ultimately seized and sold to satisfy the money judgment. As you read the case, I mean, as you read the actual opinion, you're not real sure. Did Neff obtain this property before the judgment was entered or after the judgment was entered? Well, we don't need to worry about any of that because Mitchell didn't want the property. Uh, he didn't want any property. Well, he wanted property, but he wanted property in terms of money, right? So he couldn't have filed in rem. In addition, if Neff did have property, if Mitchell would be willing to accept a parcel of property as payment, Mitchell would have had to identify and attach that property at the beginning of the lawsuit, assuming the property was within Oregon. That didn't happen. Now, Mitchell could have filed quasi in rem, right? Because he doesn't want the property, he wants his money. Had he filed quasi in rem, he would have identified parcel that was in Oregon that belonged to Neff, that upon winning, Mitchell would have been able to liquidate to get his judgment paid. But in order to do that, he would have had to identify the property at the onset of the lawsuit. And he didn't do that either. So Mitchell filed in personam. Great. I know it sounds a bit redundant and it is intentionally repetitive because once you can find your feet in this foundation and get these placeholders in place as you continue to climb up the steep hill of the evolution of personal jurisdiction, having footholds that are secure is going to make that climb a lot easier. Okay, so Mitchell filed in personam. What do we know? We know that when the court is exercising in personam jurisdiction, right, resulting in a money judgment, the court is going to direct the defendant to be personally liable. That means that the defendant is personally obligated. We've already talked about the potential ways to satisfy that judgment. We talked about why Mitchell could not have filed in rem, right? There was no property attached at the beginning. And we talked about why Mitchell could not have filed quasi in rem. Again, there was no property attached at the onset. Who are the parties in the original suit? Marcus Neff, who's the defendant, hired a lawyer for real estate purposes. John Mitchell was that real estate lawyer that Neff hired. Who is Pennoyer? When Mitchell sued Neff and won a money judgment, Mitchell moved to execute on that judgment by having the sheriff seize later, after the lawsuit, a piece of property owned by Neff. The only reason that the property is seized is so that the property can be sold. When the property was sold, the money was given to Mitchell. The Mitchell is now paid and is happily on his way. Well, Pennoyer is the person who bought the land. So that's who Francis Pennoyer is. He actually bought Neff's land. Okay. Procedure history. Again, John Mitchell sued Neff in Oregon State Court for unpaid legal services. Mitchell wins. Neff eventually comes back to Oregon from California, where he actually resides, finds out that his property is now in the hand of Pennoyer, and Neff said, hold on a second, that property belongs to me. Pennoyer says, no, I don't think so. Neff said, fine, I'll sue you. And he did. And he won. Once that was done, Pennoyer said, well, this isn't right. I've got all of my papers in order. I did everything that I was supposed to do. I've got my receipts. I've got my titles. Having felt that he, Pennoyer, had been wronged, Pennoyer sought review, and the United States Supreme Court said, let's bring it up. And that's how we get Pennoyer as the appellant versus Neff as the appellee. Okay? Fantastic. See, so much easier than you ever thought this was. We've already kind of gone over the facts a bit. Mitchell filed the suit in personam. Mitchell alleged that Neff had property in Oregon. Neff owed Mitchell money. Neff lives in California, never lived in Oregon. Mitchell went to court to get permission for substituted service since Neff didn't live in the state of Oregon. That substituted service was granted and it was executed as a publication, right? Once everything was said and done and the publication was complete, Neff um, lost the lawsuit. Neff was defaulted. And essentially, Mitchell went to court, said, Judge, we've done 1, 2, 3, 4, 5. Let me prove up that he owes me this money. I'm asking for a judgment in that amount. And it was granted, right? Sometime later, Mitchell executes on a piece of land owned by Neff. Sheriff goes out, seizes it, sheriff sells it to Pennoyer. Pennoyer pays for it. The money for the land goes to Mitchell. Mitchell's attorney's fees are now paid, and Pennoyer walks away with the land until, lo and behold, Neff comes back to Oregon. Those are the facts. Okay. What is the legal issue? What is the question that needs to be answered? I wrote this issue statement 3 different ways. And I tell students all the time, there's lots of different ways to write this issue. So, to write an issue statement, don't feel like you are forced into some foreign, unreal uh, space of just having to memorize and recite quote unquote magic words, right? The issue statement is important, not just in law school, but in practice. Because if you can isolate the actual legal question that's being asked, it's going to make your life as a lawyer so much simpler, right? You won't be distracted about this thing or that thing. You won't look at facts that are irrelevant or, right? If you can just focus, what is the question that's being asked? And if you can identify in the beginning the rule of law that is going to yield the answer, oh, it makes the whole process of analyzing it so much cleaner, so much easier to organize, right? So for my students who are writing issue statements for me, my requirement for issue statements follows what is preferred by the NCBE. That's why I have a 3-point issue statement. Now, if you have a professor who has a 10-point issue statement, or if you have a professor who prefers the organization of CRAC or CURPAC or something different, please respect the decorum of that classroom and respect the wisdom of that professor and write the issue statement and everything else the way that they've asked you to do it, because they have an intentional desire to teach you something. And so they're going to ask you with intention to do certain things certain ways. Get over it. It's fine. When you're in practice, you're going to have judges who want it the way that they want it, which is going to be different than the other ones. You're going to have supervising attorneys, managing attorneys who want it the way that they want it, right? Part of being a lawyer is learning how to be flexible and how to pivot, right? So it's fine. For me, I want an IRAC and I want a 3-point issue statement. In the illustrations, the rule of law is going to be identified in the blue highlight. The legal question, this is the question that's actually being asked, is going to be highlighted in yellow. And the dispositive fact, this is the fact of facts. This is the fact that if we didn't have this fact, we wouldn't have this question, right? We might have a different question, but it wouldn't be this one. So one example is whether, under the doctrine of personal jurisdiction, an Oregon state court may validly assert personal jurisdiction over Marcus Neff, a non-resident defendant, never consented to the court's authority, never received personal service within the state, right? That's the question. Stated a different way, does the due process clause permit an Oregon court to exercise personal jurisdiction over Marcus Neff, a non-resident defendant who did not consent to the form and was never personally served in Oregon, right? Here's a different way. Under the due process clause of the 14th Amendment, may an Oregon state court exercise personal jurisdiction over Marcus Neff, a non-resident defendant who neither consented to jurisdiction nor was personally served within Oregon, right? Probably can come up with, just going over those three, you've probably thought about 10 or 20 other different ways. But we have highlighted what rule of law is the rule of law that is required for us to analyze. Well, it's the due process clause of the 14th Amendment. What is the ultimate question that's being asked? The question is, did the Oregon court, can the Oregon court, how does the Oregon court, if the Oregon court can exercise personal jurisdiction, right? Well, surely they can, right? Why wouldn't they? Because, here's my fact, I have a non-resident defendant, and the non-resident defendant didn't consent to Oregon, and the non-resident defendant wasn't served in Oregon. With those facts, can the Oregon court validly assert personal jurisdiction? Get it? Moving on. I explained the 3-point issue statement, NCBE preferred, etc. What is the holding of Pennoyer v. Neff? Well, I think we all know the holding, right? The U.S. Supreme Court held that the Oregon State Court lacked personal jurisdiction. If personal jurisdiction is lacking, that's one of the three components for a valid judgment. What does that mean? That means that Oregon's judgment against Neff was invalid. What does that mean? That means that it's void. What does that mean? That means that it's not enforceable and it's inconsistent with the rule of law. What does that mean? That means it's not worth the paper it's written on. What does that mean? That means that the land that Pennoyer bought wasn't available to be sold, which means that that land does not belong to Pennoyer. It belongs to Neff. Okay? The U.S. Supreme Court held that service by publication on a non-resident defendant in an in personam action when the defendant did not consent to the jurisdiction of the form state is insufficient. Boom. For jurisdiction, the non-resident defendant must personally be served in the form state, or obviously can consent, or obviously the plaintiff can have property attached at the outset, that's at the beginning of the suit, but now it's not an in personam suit. Now it's either an in rem or a quasi in rem suit. Because the original judgment was void, not voidable, but void, the sheriff sale of Neff's land was also void, which means Neff got his property back. What's a rule statement for personal jurisdiction under Pennoyer? Right? Remember, I said you're always going to have those two phases. You're going to have the statutory authority and you're going to have the constitutional authority. What else did I say? I said it's going to be the constitutional authority that we're going to be watching because that's what's going to man them. That's what's going to be refined. At the beginning, it starts off under Pennoyer like this. Under the Due Process Clause of the 14th Amendment, a state court may not exercise personal jurisdiction over a non-resident defendant unless the defendant is personally served with process while physically present in the forum, or unless the non-resident defendant voluntarily appears or consents to the court's authority, because you can always consent, or the non-resident defendant owns property within the form that has been attached at the outset of this proceeding to support an in rem or a quasi in rem action. If you want to actually see this language, I gave you the Penn site, 714. Or actually, I didn't give you the Penn site. I thought I gave you the Penn site, but I didn't. But it's in Pennoyer v. Neff. Okay? 5 points. 5 the United States Supreme Court made in their analysis. 5 points. Point number 1, state power over a non-resident defendant is based upon geographical boundaries. It's rigid. And that stands squarely in line with the formalist judicial philosophy. As we go through these cases, you're going to see two judicial philosophies. You're going to see formalism and you're going to see pragmatism. formalism and pragmatism. Formalist like bright line rules. Formalist like predictability. Formalist like consistency. Give me a rule that I can apply in any and all situations. That's what you got with Pennoyer v. Neff. Geographical boundaries is it, right? Pragmatists, on the other hand, are going to look more at balance. They're going to look at fairness, which means that it's going to be less rigid. Yeah. Right now, with Pennoyer v. Neff, we have the formalist speaking. Analysis point 2. Service by publication exposes the limit. What do I mean? Publication in an Oregon newspaper satisfies notice, kind of loosely. I mean, in 1877 it did, because that's how news was shared. It was published in the newspaper, and lots of people read the newspaper. And so if there's any chance that it's going to be seen, it made sense. Publication will get you there. But the United States Supreme Court said, but there's a difference. There's a difference between authority and procedure. Remember, what do you need to have a valid judgment? You need to have authority. That's going to be your personal jurisdiction, your subject matter jurisdiction, and you've got to have your procedure. What's that? That's your notice and your service of process. And so the court in Pennoyer said, while publication may loosely satisfy notice, it does not establish jurisdictional authority. Mm-hmm. What do we know about a valid judgment? I have to have all three: personal jurisdiction, subject matter jurisdiction, notice and service. If I don't have all three, I don't have a valid judgment. Got it? If I don't have all three, I don't have a valid judgment. Analysis point number 3. If I don't have jurisdiction, I don't have a valid judgment. Oh my gosh, this is making so much sense. Analysis point number 4. The court linked jurisdictional principles to the due process clause, and I'm going to show you how. Due process requires notice and an opportunity to be heard, right? Notice and an opportunity to be heard before you can be deprived of liberty and property. What you're going to learn when you get to constitutional law is the due process clauses, both of them, the 5th and the 14th, right, have two foci, right? Focus number 1 is procedural due process. That's the notice and an opportunity to be heard, right? Foci number 2 is substantive. Right? And we're not going to do a deep dive into constitutional law because your constitutional lawyer, constitutional professors are going to knock that out the box when you get there, right? But it's important to understand that this due process clause, this procedural due process, is saying you cannot be deprived of property if you don't have notice that somebody wants to deprive you of property, and if you don't have the opportunity to prevent them from depriving you of property, right? If Oregon could bind Neff with no personal service no presence in the state, no property attached in the state, then they would, in fact, be depriving them of property without due process of law, which is a 14th Amendment violation. What began, this is analysis point number 5, as a procedural defect. Procedure, this was a procedural defect, wrong type of service. It was the wrong type of service, right? Became constitutionalized. A state court cannot, consistent with due process, enter a personal judgment against a non resident who is neither present in the state, nor served in the state, nor consenting to the jurisdiction, nor tied to the state by property that's within the state that was attached at the onset. We talk a lot about the 14th Amendment. Here's the 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's the birthright clause. You may have heard about it in the news over the last 6 months. No state shall make or enforce any law which abridges the privileges or immunities, nor shall any state deprive any person of life, liberty, or property without the due process of law. There it is, right there. Last point. Oh, actually, I just realized this is the same slide. So it is 5 points, not 6 points. Okay. Personal jurisdiction, 3 categories: in rem, quasi in rem, and personam. In personam requires more than in rem or quasi in rem. More effort, more diligence, more dedicated commitment to ensure that the non-resident defendant has an opportunity to be heard and knows that they need the opportunity. 2 prongs of personal jurisdiction. You've got your statutory authority phase, which is generally going to be, again, a long arm statute, which, again, you're not going to discuss a lot because there's potentially 50 different long arm statutes. And so usually in a hypothetical situation, you're going to find that the statutory authority piece, the long arm statute, is often, not always, but it's often addressed like this. The requirements of the long arm statute have been satisfied, or they're not spoken to at all, right? Okay. Prong 1, statutory authority. Here's the question. Has the form provided statutory authorization for jurisdiction? Where would that come from? It's going to come from a state law. How does that actually look? Usually looks like a long arm statute. Okay. Prong 2, which is really where our focus is as we traverse this evolutionary arc of personal jurisdiction, right? Prong 2, the question is, even if the state authorizes jurisdiction under prong 1, right? Even if the state does in fact authorize jurisdiction under prong 1, does the Constitution permit it? Do I have authorization under the state authority? And if I have authorization under the state authority, does the Constitution permit it? Amazing, right? Profound. Yeah, I like tables. I encourage my students to create a table to track the progression of evolution. You might not like tables. You might like charts. You might like diagrams. Um, you might like just writing it out in a narrative longhand. However, your brain works, it's beautiful. Don't change your brain to try to work like somebody else's brain. Work with your brain the way that it works. Find out how best your brain processes information. And once you find out how best it processes information, process the information that way. Because if you force your brain to try to process it in a way that is foreign or in a way that doesn't suit your brain, a difficult job is going to be closer to impossible. I like tables. We started a table with Pennoyer v. Neff, and you'll see that 1, 2, 3, 4, 5 of the 5 columns, 4 of them are not addressed. That's because I know that they're coming, and I wanted to be able to capture all of it with one table. So I have a column for general jurisdiction. We're not there yet. I have a column for specific jurisdiction. We're not there yet. I have a column for minimum context. We're not there yet. I have a column for fair play and substantial justice. We're not there yet. Where are we? We are at the constitutionalization of personal jurisdiction under the Due Process Clause. And at the moment, service and notice is just being treated as a checkbox. But when we get to Mullane v. Hanover, you're going to see that service and notice is going to be brought up to a constitutional level, just like we did here. Hopefully, that was helpful. Hopefully, that was a simple layout of the foundation so that as you walk these repeated steps over the next couple of weeks with the evolution of personal jurisdiction, you will be able to track how the constitutional part of personal jurisdiction actually gets satisfied. Thank you for the opportunity to serve. I hope that it did serve, and I'll see you in video 3.